There was a lot of discussion concerning that previous ordinance. And I think one of the things that has to be done is that the ordinance has to be quoted correctly. The ordinance provides, again, keep in mind, this is dated back to 1965, re-adopted on the charter change in '88. This insurance program shall not entitle any employee or other person hereunder to receive remuneration in lieu of accepting the benefits of this program. That language does not say, as was represented, that the township shall not pay remuneration, but it indicates that participation in the program does not entitle an employee to remuneration. That statement was true in 1965, since in 1965 there was no waiver, was no stipend. That was done in 1995 by an act of the legislature, Public Law 1995, Chapter 259. Oddly enough, that same statement is applicable today because nothing under the new act entitles any employee to remuneration. It's optional with the governing body. So the language shall not entitle, that language is correct even today, right? That there is no entitlement, it's only at the discretion of the governing body. Now, in 2008, again, as I indicated, 1995 was the first time the applicable section was, it was a new section actually that provided a waiver and stipends for the waiver. That statute, by the way, which is, I think it's section 31A of the statute, actually makes a distinction. Well, the original statute made no distinction. It was 10% of the amount of premium savings, right? Since the Act further provided that if you waived out, you didn't have to pay the premium, you didn't have to pay the insurance premium. And as I indicated, that entire statute, with the waiver and the options, was a statute designed to save municipalities money by reducing the cost of the insurance by not paying the premium, and essentially encouraging employees to waive that by providing some type of stipend not to exceed 50%. In 2010, that statute was amended, and it made a distinction between employees who filed for the waiver prior to the effective date of the Act, which is May 21st, 2010, and those that filed a waiver after the date. After the date, regardless of when one was employed, if you filed the waiver after May 21st, 2010, it was limited to 25% of the cost savings or a maximum of $5,000. If you filed a waiver prior to May 21st, 2010, I guess it's on it prior, 2010, then the 50% threshold still applied at the option of the municipality. It was permissive. So both options are permissive, and a governing body could provide all, none, or anything in between for both pre and post May 21st, 2010 waivers. So that's what's optional. But the statute does draw a distinction, right? That was, the legislature did that, that's not the council. Now, in 2008, the council adopted a resolution to make use of the 1995 statute permitting the waiving of coverage and paying the stipends for that. Again, if you read the ordinance as not entitled as a prohibiting, but just not requiring or mandating, right? Then there's nothing illegal about that payment at all. The council did in fact authorize it by resolution in 2008. That resolution did in fact only reference the 50%. And the reason for that is that the statute, that's all it provided for back then. When the legislature passed the 2010 Act, the legislation superseded the policy.
Excuse me, can we please, so we can catch the attorney's stuff on the tape? Thank you.
The legislation superseded the policy, which meant that any employee that filed after May 21st, 2010, the maximum permitted was 25%, right, or $5,000. And that did not require further action of the governing body to reduce those benefits from 50% because the legislature essentially preempted that field by saying you can't now do it at 50% anymore. The max was 25%. So that's why there was no subsequent resolution to reduce it, because the state statute automatically reduced it and preempted the local ordinance, or in this case, local resolution. Since the ordinance did not specifically prohibit, but rather merely said the participation in the state health program did not entitle, the resolution, which is resolution 148-08, was presumably valid. Keep in mind a filing of a waiver is a administrative action which, once filed, is good for as long as presumably the statute permits it, okay? Because no further action is required. The waiver is filed once. It's not refiled each year. It's filed only once. A lot was said about the Board of Education's application. If you hand someone an application today, you can only do 25% up to $5,000 because it's by definition being filed after May 21st, 2010. So there is no option. So that form is perfectly fine today because there's no alternative. The real question is what happened prior to May 21st, 2010? What was the application like? Okay, but that's another issue.
Well, you know, it's very difficult because I can't answer these questions. So.
I don't know if I've asked a question, but so I do not believe that the council is guilty of misconduct in office. And those who use that term, that is a serious allegation. Misconduct in office is a very, very serious offense. It's a felony of the second degree. Okay? And again, it's regrettable that people should resort to that type of language.
And that's why I felt that.
And I can only go back to a conversation I had with Mr. Rupp some weeks ago about needing an ordinance to change an ordinance. And I believe that we changed good and welfare and limited the public's time to speak to 5 minutes, or from 5 minutes to 3 minutes with a resolution. And as I am not one who was in support of that, I just want to make sure that, at least during my tenure, if we're going to do something, and we're going to, at least of that measure, that we do it by way of an ordinance as opposed to the resolution. And
Again, my concern is that there was a very, very clear discussion that this would be temporary.
Mayor, if I could just note that all resolutions are temporary because they all expire at the end of the term of the council. In Teaneck's case, it's actually 2 years.
Mr. Kramer.
Martin Kramer, Teaneck. As the former township attorney, my message to you, given the insufficient 3 minutes allotted, which is going to force me to read this, I don't like to read things, but I have no choice, is that while the present township attorney, Bill Rupp, is a very nice guy, he has given you the wrong advice about the health benefit waiver program. In Teaneck, since 1965, it is absolutely illegal to either receive or to pay any money to waive benefits in the New Jersey Health Benefits Program. How do I know this? Well, I read the Township Code, as anybody can do. It's there on the Teaneck website. And in 1988, I arranged, rearranged, codified, recodified, and partly wrote some of that code. So I'm somewhat familiar with it. Both of the two sentences involved in the ordinance that is involved with the section 2-152E. The first sentence is a flat prohibition stating that no employee can get any money for waiving health insurance benefits. And the second sentence says that no one is entitled to get money for waiving those benefits. It's not just any old ordinance. It's a hell no ordinance. You can't do it. You can't pay it. You can't receive it. Mr. Rupp quite incorrectly tries to ignore the first sentence of that section, and he also very incorrectly misinterprets the second sentence. He admits that while employees are not entitled to receive waiver benefit monies, the township can still pay it. That makes no sense at all to me. Both the receiver and the payer of the waiver monies are involved in a conspiracy to violate the Township Code. And I might remind you that there's a penalty phase in the Township Code of $500 for a violation. But that's $500 a day. Going back to 2008, it's about $1.5 million now. But it's the deleting of the first sentence as a catch line, and I heard Mr. Rupp say it 2 weeks ago, that is even more disturbing to me and should be disturbing to all of you. A catch line, as defined in another section of the code, says that you can ignore some words as a catch line only if it's a section heading and if it's in bold-face type. The words we're talking about are not section headings. There are 1,216 sections in the code. I was so angry I counted them. This is not a section heading, and it's not in bold-face type. You can't ignore it. You can't just delete it and cut it out. So it's a clear violation to either pay or receive that money. But then you say, what about there's a 2008 resolution which permits
Thank you, Mr. Kramer.
payments and which you've paid under. That resolution is illegal because the standard rule, as Mr. Rupp well knows, is no resolution can amend, modify, or change an ordinance. The ordinance is paramount.
Can you submit would you mind submitting
sure can.
Thank you very much, Mr. Kramer. Excellent. Mr. Attorney?
Yes, Mr. Mayor. I happen to have a copy of Ordinance 3158 in front of me, which is the 1988 ordinance that readopted Chapter 2 as a result of the charter change to which Mr. Kramer alluded earlier. The section in question has the Section E. Contrary to Mr. Kramer's statement, the first clause is not a sentence, and I would refer anyone to any English teacher to verify that it does not have a predicate in a subject. Second of all, it is in bold print, right? Second of all, and thirdly, it's underlined. It is clearly a catch line under the terms of the ordinance. And again, I have a copy right here, so my advice earlier is give it stands.
I can't have back and forth. You can speak to him right after the meeting.
My copy has bold print and underlined, and it's not a sentence. And it's just like the other catch lines in the remaining paragraphs of that same section.
All right, thank you.
I would also comment that the council, of course, any 4 council members can get together, and I'll be happy to prepare the appropriate ordinance on whatever it wishes on the waiver.